Hello, everyone, and welcome to this month's webinar on political affiliation discrimination in the workplace.
Our guest speaker today is Wayne Wysong, an attorney who is licensed in multiple states.
Today's topic of political affiliation discrimination in the workplace is particularly timely as it is a sensitive issue that many employers are dealing with on a day-to-day basis. The National Labor Relations Act prohibits employers from disallowing employee discussions of workplace conditions. So employees may discuss why they believe a certain candidate is better for them as a worker without being fired for having the discussion. It appears that employers can force employees as a captive audience to attend meetings and listen to one-sided political pitches on behalf of candidates. Oregon has a law prohibiting such employer conduct, as does New Jersey. While employers can prohibit wearing of most political buttons, shirts, and other campaign items, it cannot prohibit union insignia if a union is in place in the business. Some states and localities prohibit employers from firing or disciplining employees for legal activities outside of work. In such states, an employee cannot lawfully be fired as long as the activity is legal. If an employee works under a contract which says an employee can be fired for cause, the contract should be very clear on what constitutes cause. If it prohibits certain political activities, and assuming it is lawful to limit them, the contract should describe exactly what are considered prohibited political activities. Most states, but not all, require employers to let employees take time off to vote. The employer's written policy should emphasize this and urge employees to be very careful about any remarks or comments that others might find politically offensive. Political speech and activity, especially in the private sector employment, is not well protected by anti-retaliation laws. The law may protect employees in some places. Federal employees, as I mentioned, receive broad protection. It's important to check with your specific state because what activities are defined as political varies between states and localities. Illinois, New York, and Washington states prohibit employers from discriminating against employees for election-related speech and political activities. Arizona, Washington, D.C., Georgia, Iowa, Minnesota, Missouri, Ohio, Oregon, and Washington prohibit employers from discriminating against employees who have signed initiatives, referendums, recalls, or candidate petitions. Finally, Louisiana, Massachusetts, and Oregon prohibit discrimination based on contributions to a specific campaign. As you can see, the laws vary greatly around the country on this point.
And what if an employee conducts political activities away from the office, for example, during their lunch hour?
Well, Leon, in most states, there is no law against political activity retaliation. An employee could, in those states, be disciplined or fired for leaving work to attend a rally or other political event, even if they are allowed to leave for lunch and do not exceed the allowable lunch period. However, employers who allow their employees to leave the premises for breaks should consider whether it is really worth the effort to discourage such political activity. First, it's not terribly good for morale. As a practical matter, such restrictions are very hard to enforce, especially with exempt employees who may have no lunch period restrictions. Employees who do not have legal protection under anti-retaliation laws should be aware that their risk is higher if the political views they support conflict with the views of the company or superiors. In general, employees should not let any kind of outside activity interfere with work. Even if the company does not strictly enforce the lunch hour, a wise employee should not take advantage of this by being absent for too long, regardless of the reason. Issues of what workers can do while off duty, like attending rallies and working for political candidates, have raised questions in the past, but the internet has intensified the debate. It is generally unwise for an employee to post a photo of himself or herself on social media. It can get the employee scolded by the boss, if not fired. Workers should think twice about publicly posting any selfies, particularly if they highlight any political activity they are involved with at the time. Some things employers can do to prevent excessive workplace political activism include prohibit political conversation. However, some states explicitly forbid private companies from restricting free speech, so this will not work everywhere. If the employer can't outright forbid political speech, it can take action to discourage political speech, which might cause potential workplace conflicts. If nothing else, sensitivity training is always an option. ask people to voluntarily limit political discussion, express concern that it could harm the overall workplace environment and lead to tensions among workers that can harm productivity. And of course, that means harm raises, harm bonuses, get them in the pocketbook. Update the employee handbook. The employee handbook and code of conduct can be used to communicate the employer's expectations for employees in the workplace. It should emphasize that all employees must treat each other with dignity and respect differences in opinions. So as an employer, be sure to avoid drafting overly broad provisions and remain neutral.
For additional information from Personnel Concepts on human resources related topics, select a video on the screen. Subscribe now for HR and labor law updates.